So whoever's signing in on the, there we go. If you can unmute on the Samsung device, please.
Yes,
There
sir.
we go. Can you tell me your name, please?
My name is Melvin Lafreniere.
Okay, great. And Mr. Zayat, are you able to hear me okay?
I can, Your
Yes,
Honor.
sir.
Thank you very much for accommodating us.
Okay, great. So we'll go on the record. This is People versus Lafreniere, case number 245285. We have defendant and counsel present by Zoom today by prior approval of the court, and Ms. Koch is here in person. This is set as a status conference today. So Mr. Zayed, can you tell me where things are at on the defense side?
Yes, Your Honor. And for the record, Justin Zaid, PA 1051 on behalf of Mr. Lafreniere, who is present and consents to appear via Zoom. Your Honor, as you indicated, this is the day and time set for a status conference. Your Honor, the reason we asked for Zoom and what we're going to be asking is for a continuous of another status conferences. Part of a resolution in this matter is contingent upon Mr. Lafreniere getting accepted and onboarded into a treatment court program, preferably down here where he resides in Metro Detroit. There has been wait lists and some delays in getting him into a program that's both sufficient for the resolution in this matter, as well as for the court that's going to be taking him on. We are narrowing in on a veterans court program, Your Honor, and we do anticipate, if we are given 30 days, that we will have one identified and accepted into such that we would be able to reach a resolution on the underlying matter.
All right, thank you. Ms. Koch?
Yeah, this case, just so the court's aware, is, and I know it just got found over in January, but I made the offer for the Veterans Court, Sobriety Court in September of last year. We are going on 10 months of this case. I understand Sobriety Court is having issues. I understand Veterans Courts are having issues, but we need to get this case either resolved within 30 days or on the trial docket. It has been lingering for far too long. Thank you.
I agree. I agree.
Okay, all right. So I think everybody recognizes this case was found over in January. We've had a number of adjournments already. I believe one in March and one in May to get us to this day here today. So yeah, Mr. Zayed, I think we're running out of time here in terms of the court's willingness and ability to continue to adjourn this out. So we'll set this for another status conference / plea hearing in about 30 days. If we don't have a resolution at that time, then I think the courts would have to get it set on the trial docket, and then we'll go from there.
Understood.
Mr. Zayed, anything further we can address for your side here today?
Nothing further, Your Honor.
Okay. Ms. Koch?
No, thank you.
Mr. Lafreniere, did you have any questions at all about how we're going to proceed?
No, Your Honor.
Okay. All right. Thank you. That concludes this hearing. All parties on this case are free to disconnect at this time.
Thank you very much.
People versus Paul Kuhn, case number 235256.
Sierra Coke on behalf of the people.
Kuhn is present here in the courtroom today. This was originally set as a sentencing hearing. Mr. Kuhn, I got a report from the Probation Department indicating that you declined to participate in the investigation process.
Up here. Greetings, Your Honor. I'm here by special appearance, not a general appearance, and I reserve all my rights and explicit reservation without prejudice. I, Paul Kuhn, a sentinel moral being, have examined the path of my feet on and have concluded that I have dishonored many people, including, but not limited to, the people, the peace officers, the city, the county, and to determine that I have made many mistakes, and I'm sorry for my sins, and therefore I repent now. I have become aware of other sins I may have committed, and I'll repent immediately. to my attorney, it has come to my attention that you have never informed me of my choice of law. And to make matters worse, you chose to, an inferior form, to have me tried under. You are either incompetent or collusion with the prosecutor. Either way, you have provided me with effective assistance of, or ineffective assistance of counsel, which has caused me great harm. You are fired. That's what I have to say.
Okay. Do you intend to hire another attorney? Are you appointed?
I was appointed.
How are you going to proceed in terms of counsel, Mr. Cohen?
I'm gonna do it myself.
Okay. All right. You understand that you have the right to have an attorney,
I do.
and you understand that if you can't afford an attorney, you have the right to have one appointed for you at public expense. And in fact, that's what we've been operating under up till now.
I haven't gotten legal counsel, but anyways, I'll accept whatever you have.
Okay, so you understand that you do have the right to have an appointed attorney if you can't afford one?
I had him and he has done me no good from the beginning, so.
Yep.
At this point, I'll just I'll take whatever you got to give me.
Yeah, I'm just asking whether you understand that you have that right.
Yes.
And in spite of that, you're asking the court to allow you to represent yourself today?
Yes.
Have you ever represented yourself in court before?
Sir, I'm just I'm here as a special appearance only, and that's,
Yeah, that doesn't have any legal significance to me at all.
I understand.
My question is whether you've ever represented yourself in court before.
No,
Do you have any legal training or education?
no, just have the people that help me get through this.
Okay. And so you understand that there are, not having represented yourself, not having any legal training or experience, that there are risks involved in representing yourself,
Yes, sir.
and that there are matters of procedure and substantive law that you may not be aware of, and therefore there may be arguments that you could raise in your own defense that might give you an improved outcome in your case, and that without that legal training and experience, you may not know what those are, and you may have a worse outcome than if you had an attorney.
I'll take what is given to me.
In spite of those risks, is it still your wish to represent
Yes, I'll
yourself?
take what is given to me.
That's not the answer to my question. My question is, do you still want to represent yourself knowing those risks?
Sir, I just I'll accept any offer. In return, your offer to your, for your closure and settlement of any account I may have.
Okay, again, my question is, in spite of the risks of representing yourself, are you still asking to represent yourself?
Yes.
So at this point, the court, with Mr. Germerty will discharge you. The court finds that your request to represent yourself is knowing and voluntary and unequivocal. And so at this point, the court's going to allow you to represent yourself going forward. Do you have anything to say with regard to your refusal to participate in the pre-sentence interview process?
Whatever you want to give me, I'll accept.
Okay, so that's something that you're required to do as part of the court's order. Because you declined to do that, the court is going to revoke your bond. The court is going to order that you be remanded to the Crawford County Jail. I'm going to request the probation officer to make another attempt to go through the pre-sentence interview process with you. If you continue to decline, then we'll just go forward with sentencing without having that information before the court. And Mr. Haven, if Mr. Kuhn refuses to participate, you can just indicate that for the court, and then prepare the pre-sentence report to the best of your ability without that information.
Yes, sir.
I did an acceptance, dated and signed the top of it. And that's all I'm doing.
Okay, well, we'll give it another try anyway, and you're gonna do what you're gonna do, but for today's purposes, the court's gonna revoke your bond and remand you to the jail. The court will set this for a sentencing hearing at its next available date. So, you can go with the officers, please.
Okay. Can I hand this over to my witnesses? Hmm?
I'll give it to him.
Okay, right there.
Yeah.
Sorry, just, sir, could you hand that to them? Okay.
He's off.
Oh, the headphones. Okay. So you don't need those, I mean. Oh, okay. Okay.
Mr. Gerke, you have Mr. Funk available?
I do, and I'm gonna go there.
On the record in People versus Dustin Funk, this is case number 245296. The record should reflect that Mr. Funk is present here in courtroom today.
Yeah.
I can have counsel please, sir.
Sierra Coke on behalf of the people.
I think you're ready, Mr. Parker's just saying.
Mr. Gerke, can you tell me where things are at with this file?
Yes, Judge, Mr. Parker is gonna tender a plea of guilt to a one-year misdemeanor use of tramadol. Count 1 in the habitual fourth offender notice will be dismissed, including count 2 as well.
Ms. Koch, is that a correct statement of the offer?
It is. The PAT code for controlled substance use is 333.74042B. It is a one-year misdemeanor with a maximum fine of up to $1,000, mandatory AIDS and hepatitis testing if it's intravenous use. In this case, it was not.
Okay, thank you. Mr. Funk, have you had a chance to talk to Mr. Gerke about this plea agreement?
Yes, sir.
Okay, and is that how you want to proceed today?
Yes, sir.
And raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Funk, are you currently on any kind of probation or parole?
No.
And you understand, as we've said here today, that the maximum possible penalty that you could face for use of tramadol is up to 1 year in jail.
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Yes, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial and to not have that silence used against you. You have the right to testify at a trial yourself if you want. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened back on November 13th of 2023. Is that the correct date?
Yes, sir.
Okay. On that date, were you here in Crawford County?
Yes, I was driving through.
Okay. And at the time that you were driving through Crawford County, did you have some tramadol?
Yes, I did, sir.
Did you have any legal right to have that substance at that time?
No, sir.
Okay. Did you know that that's what that substance was?
Did I know what it was?
Yes, sir. Okay. All right. Ms. Koch, are the people satisfied with the factual basis?
Yes.
Mr. Gerke?
Yes.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Gerke?
No, Judge.
And Ms. Koch, are the people satisfied that the court has complied with statute or rule when taking this plea?
Yes.
I would agree.
Mr. Funk, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a separate sentencing date. You'll be notified of the date and time of that hearing. It's just important that you stay in touch with your attorney prior to that day, okay?
Okay.
Also, before you leave court, you're gonna meet with Mr. Haven. He's the probation officer. And Mr. Haven, if we could just have a misdemeanor report prepared on this one.
Will do, Your Honor.
Okay. Anything further to scope on this case?
No, thank you.
No, sir, thank you.
Thank you, Mr. Funk. That's all for today.
All right, thank you.
Okay, and then Mr. Church, my understanding that the victim is en route. So I think there were some delays in getting him here today. But we have him ready to go. Are you gonna need a minute to speak with him or have there?
No, I think we're already on his matter.
Oh,
They did let the officer know when he arrives here to just bring him to court.
okay. So we'll take a brief recess until Mr. Victim is present. We're on the record in People versus David Dickman. This is case number 204590. If I could have counsel for this, please.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Bickman.
This is a big time set for a sentencing hearing in this matter. Mr. Dickman, did you have a chance to go through the probation violation report? Mr. Trush? Yes, sir. Mr. Trush.
Your Honor, the only deletion that I would ask, it appears that there is a victim impact statement from the underlying charge. From the charge in Otsego County that's been attached to this. I would ask that that be removed under the Crime Victims' Rights Act. I don't think that person has the authority to make a statement in this case. I do think that the original victim in this case would have the authority to make a statement in this case, but under the Crime Victims' Rights Act, I don't think the victim in the Otsego case has the authority to make a statement here. I think they're only entitled to make a statement in the Otsego case, which I believe that's where this report came from.
Ms. Coke.
Your Honor, I would disagree with Mr. Truce's assessment, given that the allegations in this case are in relation to that case. So I think it's important to have that statement as it relates to the underlying allegation.
Yes, I had a chance to look at this issue because I did obviously see the statement that was attached. And it's my view that because the violation conduct involved charge that was essentially the basis for the violation in this case, I think it is appropriate for that to be made part of this file. And so the court is going to have it remain attached to the PSI. And I did have a chance to review that. I think certainly Mr. Trush, the court has to keep in mind that the sentencing here is for CSD charge, but I think the court can also take into account the facts surrounding the violation here, just as if it was any other type of violation, determining how serious the violation was and how that affects the original sentencing. SI. So having made that record, any other additions, deletions, or corrections?
No, Your Honor.
Okay. Ms. Coke, do the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, when I spoke to the MDOC officer doing the recommendation before it gets sent off to review, the recommendation was originally 30 months. That had to be changed based on policies in Lansing, and it's now 12 months. But I think the original recommendation or somewhere between the two is more appropriate. I can't say anything more than this letter says. The victim in this case says it all. So I don't have anything additional to add.
Mr. Trush.
Thank you, Your Honor. There's a lot of things to consider with this. I would suggest to the court ultimately, I think the recommendation here is appropriate. And I think there's two reasons why that's an appropriate recommendation. One of which is Mr. Bickman's conduct since he's been on probation, and that is to say he's been on probation for the underlying CSC since 2020. And he's done well with the exception of this offense, meaning he's completed his counseling, he's complied with probation. So I think through that lens, he's doing well on probation, and the court should take that into account looking at what this sentence should look like. The other reason why I think the 12-month sentence would seem appropriate is taking into account what the underlying charge is, which is to say, for reasons that I can't speak to because I'm not involved in the other case, it looked like Mr. Legal might have represented him on that. Whatever he was charged with in Otsego County, they elected to offer a 1-year misdemeanor for whatever reason. And again, I don't know if it was witness issues, proof issues, or what was going on. But they offered a 1-year misdemeanor to him, which he took advantage of. Judge Hunter saw it appropriate to issue the maximum sentence that he could on that 1-year misdemeanor. And frankly, I think, looking at the victim impact statement, it's understandable why. But I think that there's a proportionality to this, and the violation here shouldn't punish him more significantly than the actual conduct. And I think that the court should take that into account. the actual conduct that forms the basis for the violation was ultimately a 1-year misdemeanor, and he was ultimately sentenced to 1 year on that. To then go back and sentence him on a violation here to a significantly longer sentence than that, I think turns things upside down, puts them on their head. For those reasons, I think that the 12-month sentence, 12-month sentence recommended in here would seem appropriate. And I would just indicate again that a child abuse 4th degree is a neglect situation. It's not an intentional act, it's a pure neglect situation. I think that should factor into what the court does here as well. Taking all those things into account, I think the sentence recommendation of 12 months is appropriate when asked court to follow that.
Mr. Hickman, anything that you want to say?
I wrote something that I would like to say, if that's all right. I'd like to say that I'm sorry for my daughter and my family. Take responsibility for what happened. I'm also sorry for the court. But I want you guys to know that I didn't do it on purpose, and it was an accident. Lost my family and my life since this happened. I took over 50 parenting classes, doing the GED in jail, so I could get a better job to support my family better. And I also held the job and paid my support, my probation fees. And I'm waiting on an appeal to hopefully be able to see my children again. But I know I have a lot of work to do. Appreciate you letting me talk today.
I did read through the violation report here, so I'm familiar with the circumstances that bring you back before the court. And also I went through the file, reviewed the underlying charges in this case, which is sexual conduct 2nd degree. So I'm familiar with all of the facts here. And so in looking at what an appropriate sentence would be, first of all, the court notes that the original guidelines in this case were 0 to 9 months. The court, of course, can depart from those guidelines if it finds adequate reasons to, and I'm going to explain that in a minute. And I do know that outside of this additional charge, that there were no other violations during your time on probation, and did pay all the fines and costs. So there were some positives there. However, the negative here is this new charge, and it's a serious charge, and the conduct underlying that charge is serious. And I think the court, as I've already indicated for the record, because that charge and the facts underlying that charge provide the factual basis for your violation in this case, I think the court can look at that other conduct. And I think I understand Mr. Trush's position that the court should not punish you more harshly in this case than in the other case. Well, I understand that argument, and I understand the logic behind that argument. I don't think it's necessarily correct from my standpoint, because I'm looking at not only that conduct, but the conduct in this case, which was your sexual abuse of a 5 or 6-year-old girl. And I think that those two things taken together warrant a more serious sentence. So that's what I'm looking at. And I don't think a 9-month sentence, or even the original sentence in this case, is adequate to account for the conduct. So if the court is going to go above those guidelines, first of all, the court has an obligation. That's your background. Objective and verifiable reasons to depart. The court has to articulate why a sentence in the guidelines is not appropriate and why a sentence outside the guidelines would be more appropriate. And the court also has to justify the extent of any departure. In this case, I think there is adequate cause to depart. Number one, your underlying offense of sexual abuse of a minor child, again, who was 5 to 6 years old at the time the abuse occurred. The fact that you continued to victimize children with this new charge that resulted in the violation indicates to me that the punishment in the original case and the probation has failed to correct behavior. In this case, I don't think it's the actual question that violation behavior. That resulted in years. Essentially defenseless and had no ability to review. And of course, the original guidelines don't take any of that into account. We're finding that those facts in and of themselves warrant a more serious sentence, and that the original guidelines didn't take any of those things into account other than the facts involving the underlying offense. And in terms of the extent of the departure, both cases, I think you have demonstrated that you are and have been and continue to be a danger to young children through sexual abuse and now physical abuse, and not just minor physical abuse, some pretty substantial abuse that resulted in severe injuries. That you're not correcting your behavior, but in fact, it's appearing to get worse since the underlying charge occurred. I think looking at your history of these two cases, it's objective and verifiable. It's not my opinion. It's your conviction and your behavior proves that you're willing to hurt minors either through sexual abuse or and that there's some evidence that you're going to continue to do so when you're on probation. So for those reasons, the sentence outside of the guidelines would be more appropriate to you in your circumstances. Crime in this case and the violation behavior. I think that a harsher sentence is warranted to protect public safety, in particular protect any other children that might come into contact with. Under the Tanner 2/3 rule, 38 months is the maximum, and I think that that's a necessary and appropriate sentence, again, to ensure that for at least that period of time, you're not going to have access to any children and not have the ability to harm them, again, either sexually or physically. So for all those reasons, the court is going to depart. The court is going to sentence you to 38 months to 60 months in the Michigan Department of Corrections. The court is going to discharge you unsuccessfully from your probation in this case. There are no fines and costs and reserves. The court doesn't have to. That doesn't go into judgment sentence. You have the ability, I'm sorry, you do have credit for 200 days served. The court is also going to order as part of the sentence that cannot have any contact with any children under the age of 17. You do have the ability to seek an appeal of this sentence, and Mr. Trush to provide those appellate rights. For the record, the court's going to order that that sentence be served concurrent to the Otsego County sentence as well. Yes.
There's no.
Yeah, I mean, it's actually.
You're remanded to the custody. Case number 23528 and 2453007.
Your vote on behalf of the people.
Mr. White is present here in the courtroom today. This is set for a status conference for the new case. That's a probation violation.
I think we're prepared to proceed with the violation here.
The people call Deputy Michael Wells.
Come forward, Sarah.
You solemnly swear or affirm that the testimony about you today should be the truth, the whole truth, and nothing but the truth?
Yes, it is.
And this chair right over here.
Steve Wells, where are you employed?
Crawford Sheriff's Office,
What is your title?
deputy,
How long have you been there?
2 years.
Are you familiar with Miss Christine Schweizer?
I am,
Do you see her in the courtroom today?
I do.
Can you tell me what she's wearing?
Orange jumpsuit.
Let the record reflect who's identified the defendant.
No,
Okay, record will reflect that.
Did you come into contact with Ms. Schweizer on 5/24/24 around midnight?
There might have been a miscommunication at the time there.
What time did you come in contact with her?
If I could reflect on her report, it's a different portion of the report, but I think it's around noon actually.
And where did you come in contact with her?
Timberley Village, in a trailer at the Timberley Village trailer.
That's here in Crawford County.
Yes.
Okay, when you came in contact with her, who was in the trailer? Was anybody else in the trailer?
No.
Do you know whether she lives in that trailer?
I know she was staying there. It's not a residency on her identification card, but I knew from prior experience that she had been staying there for a while.
And what happened when you arrived at the house?
Well, I made contact with her probation officer that Christine had warrant for her arrest. Upon contact with the house, I saw Christine through the window of the residence, and I advised her that she had warrants.
What did she do?
She wouldn't come to the door, and there was a barking dog, so she's cautious with proceeding, and I advised her that I would force entry into the residence to effect arrest.
After you told her you were going to force entry, what did she say?
She advised me to leave.
What did you do?
I forced entry to the door twice.
When you got inside, did you observe any other people in that residence at any time?
No.
What did you observe as it pertains to Ms. Schweizer?
In regards to methamphetamine,
Yes.
two pipes by the bedside that I observed to have crystalline white residue. Further testing that found it to be test positive for methamphetamine.
Now, where was Ms. Schweitzer when you forced entry into the home?
As soon as you walk in, she was laying in the bed.
Is it a bedroom? Is it a separate room?
It's a separate room from the bedroom. I'd say it's a living room with a bed in the living room.
And where was the methamphetamine in relation to the bed she was laying in?
Right to the right of the bed. I'd say within 2 feet.
Was it visible? Could you see it right away?
Yes.
Wasn't in a drawer or anything, right on the bedstand?
Correct.
How did she appear to you? Was she able to talk to you rationally?
I could tell she was most likely high on methamphetamine from prior contacts I've had with her and people high on meth. I could tell she was having exaggerated movements and talking to people that weren't present.
You said there was 2 pipes next to the bed,
Correct.
and did you Nick test both of them?
I did.
Okay, and did both of them test positive for methamphetamine?
Correct.
I have no additional questions for Deputy Wells.
Hey, Your Honor.
Deputy Wells, you made contact with Ms. Schweizer in Timberley Village.
Correct.
Now, you indicated that she'd been living there for some time.
Correct.
How do you know she had been living there?
Some deputies, 2 other deputies at nighttime went and took a larceny complaint and she was staying in Timberley Village. With Christine Schweizer.
Okay, so this is based on the fact that other deputies had seen her in Timberley Village?
Correct, and just from contacts around town, people I know that know Christine Schweizer.
advised me where she was staying.
So you have some information that said she was in Timberley Village.
Correct.
What led you to this particular trailer in Timberley Village?
Specifically, contact with a resident in Timberley Village 5 minutes prior to my contact with Ms. Schweizer.
Okay, so that is to say you showed up at Timberley, asked, hey, is Christine Schweizer here?
Correct.
And they said she's there.
Correct, and then I made contact with the probation officer at that point.
And when you made entry, was her probation officer there?
He was not as I made entry, but he ended up showing up within minutes of me making entry into the residence and putting her in handcuffs.
And to the best of your knowledge, the address that you made entry into was not her listed address with probation?
Correct.
It's not an address that was listed on her driver's license?
Correct.
That address is not connected to her any official way? Correct.
Any official way, yes.
And that address isn't connected to her through any other reports that you've had, just really that someone told you she was there right now?
Not that I've had, but the address is affiliated with the Deputy Clark and Deputy Brown's report that they had, again, with the larceny complaint.
Okay. With that larceny complaint, you said that that address is affiliated with the larceny complaint?
Correct.
Okay, and was Christine there during the larceny complaint?
Unknown to me.
Okay, so what connects Ms. Schweizer to that larceny complaint?
She was a suspect.
Okay. So are you saying that you believe that she stole from the residence that she was living at?
No, it was a larceny from another resident within Timberley Village. And I didn't have a lot of information. I just knew that she was staying at Timberley Village from other deputies.
Okay. So let's talk about, you enter into the residence, and before you enter, you know Christine is in there?
Before I entered, yes.
And that's because you see her?
Correct.
And is she talking to you before you enter?
Yes.
You enter the residence and you make an arrest?
Yes.
And that's on the basis of the outstanding probation warrants, correct?
Yeah, they were for failure to appear on possession of and resistance.
You mean the probation violation warrants?
Warrant. Yeah, I don't know if they're for probation violation exactly. I just know they were for those two original charges.
Okay, and so just to be clear though, you're not talking about the charges in this complaint that you all were arrested?
Yes.
So after you do an arrest, do you do a search of the house?
Myself, searched it back well, yes.
And during the search, you indicated that you found 2 methamphetamine pipes.
Correct.
And those pipes both had residue?
Yes.
Did you find any usable methamphetamine or just the residue?
Just the residue.
And those pipes were on the bedstand next to the bed?
Yep.
When you searched the house, did you find any of Christine's property in the house?
I found some pieces of property, if I recall, her purse, for example, a jacket, cigarettes, but you can tell that she doesn't use portions of the house. She most likely just use the living room.
So let me ask you this, you identified some personal effects that you found in the house. But those would seem to me to be the sort of things that you might carry with you everywhere, right? Like she probably carries her purse everywhere she goes. Did you find changes of clothes of hers in the house?
There were clothes all scattered all over the living room as well. Her dog was there.
Okay. So the clothes that you found, were you able to identify any of them as female clothes?
I can't recall them being specifically, you can let me up close.
What about, was there a refrigerator in the house?
There was,
Was there food in the refrigerator?
there was,
Okay. What kind of food was in the refrigerator? Was it fresh or spoiled?
it was spoiled.
Was the refrigerator running?
No, it was not.
Let me even ask that broader. Do you know if there was electricity?
In the residence,
Yes,
unknown, it was daytime.
fair enough. Now, you tested the pipes for the substance. Was there anything else you did to try to figure out whether or not these pipes belong to Christine?
No.
So,
Says question here.
what did she say when you questioned her?
I have to recall specifically, but she said they weren't hers.
So, I mean, so she denied knowledge of it. And you indicated that you believed that she was under the influence on this day?
Correct.
Mr. McFaldo was there, correct?
He was.
Did he drug test her that day?
He did not there. I don't know what he did at the jail, but he wanted, I know he had contact with her in the jail.
So what do you understand the status of Timberley Village to be right now? Is
Your
it-
Honor, I'm gonna object as to relevance. I mean, we know she was in the home. He saw her before he made entry and she was the only person in the home. We are really far outfield of a probation violation hearing.
What would be relevant?
Your Honor, I mean, I disagree. I mean, frankly, I think the court's probably aware, but I mean, those are all, I mean, the place is condemned. There's no one who has lawful authority to be in any of those places. There's nothing that connects her to this. And
I'll allow the question. Go ahead. If you want to re-ask it, maybe.
so what is your understanding of the status of Timberley Village right now?
I know there's still people staying in Timberley Village, just from contacts I've made with them, but from a legal standpoint, I know that nobody's supposed to be there.
And are you familiar or experiencing, well, you've sort of alluded to this, so people are squatting there?
Yeah. You can call it
What was the state of what this trailer she was in looked like? Did it look clean, disorderly?
that. Comparatively speaking to other trailers, it was one of the better ones that I've been in.
Did it look like the trailer was being cleaned out?
I don't know, I mean, no, I'd say, I again, I would say-
So what leads you, what observation did you make that led you to believe she was staying there or something?
her dog being there, again, there were clothing items there, I can't recall specifically whether they were male or female. And the bed there with the sheet on the bed, she was under the blanket, she looked as if she had been sleeping when I arrived. And then again, prior contacts I've had with multiple deputies and people around town advising me that she was staying.
Just one more question. Find any dog food there?
What's that?
Did you find any dog food there?
I don't recall.
I don't have any additional questions.
Can you redirect?
No, Your Honor.
Thank you, officer. You can step down. Any other witnesses, Ms. Poe?
No, Your Honor.
Mr. Kirchhoff, witnesses?
No, we don't have any witnesses.
Ms. Coke, any argument?
I think the record is pretty sufficient here. Ms. Schweizer was the only person in the house. There were 2 methamphetamine pipes within arm's length of where she was sleeping. She appeared to be under the influence. She was acting erratically and speaking to people that weren't there. Deputy Wells had information that she had been staying there. We saw her there before she made contact, and there was nobody else there. I think we've met our burden for the probation violation for the possession of methamphetamine. Thank you.
Hey, Your Honor, I think what we have here is a lot of unknown. I mean, we start with some things that I think are pretty basic. The prosecutor asserts that it appeared as though she was under the influence of methamphetamine on that day. The officer testified that that's his belief, but really, I mean, there was no attempt to establish a record that really would establish how much experience he has to be able to make such a statement. We know that she was on probation at the time and she interacted with a probation agent on that date. We don't know if a test was ever done. We don't know if she actually passed or failed that test. What we do know is that she was found in a trailer, in an abandoned trailer park, with no property of hers that really ties her to that location. What we have is that she had her purse on her and she had her dog with her. We don't have anything that establishes that she had food in the house, food for her dog, clothing in the house, anything that would really connect her long-term to this property. What we know is that there's abandoned trailers all throughout Timberley Village right now. What we know is that Timberley Village had a significant drug problem. I would venture to guess that the court, if the police were to go into every trailer there, may find used pipes in just about every one of them. I don't know that there's enough to support, even by the lower standard of preponderance of the evidence, a violation here.
All right, thank you. The court is required to follow the provisions of MCR 2.445E1, conducting a hearing regarding a probation violation. The court has to allow both sides to present evidence. The defendant has to be made aware of evidences. They have the right to be present at the hearing, produce her own evidence should she want, and certainly to cross-examine the evidence presented by the people. The court has complied with that provision. The standard of proof on the probation violation is preponderance of the evidence or more likely than not. I think that's a really important point to recognize, especially in cases like this, that this is not a beyond a reasonable doubt standard, and I think this case might be more problematic under that standard than it is under the preponderance standard. In any case, the court finds the following evidence relevant and applicable to the rule. Number one, there were 2 pipes found in close proximity to the defendant. The officer testified that those pipes had white residue on them, that they were field tested and tested positive for methamphetamine. The officer testified that those pipes were located at 2 feet of where the defendant was. They were right next to the bed that she was sleeping in, and that they were in plain sight, visible to anybody observing the contents of that room. The officer testified that the defendant was behaving in a way that was consistent with his experience of people who had been using methamphetamine. The officer testified no one else was present in the home, and that it was his belief, at least as an anecdotal level, that she was staying there. There was some personal property of hers located there. She didn't have her dog with her, according to this testimony. So the question is whether or not that evidence, which is uncontroverted for purposes of this hearing, supports a finding under a preponderance standard that she was in possession of that methamphetamine, and I think that it does. Certainly, whether or not that was her technical address, whether she was living there long term, that all goes to whether or not that was her methamphetamine. However, I don't think that is dispositive. I think the circumstantial evidence here, the location of the pipes to where she was, and the fact that she had appeared to the officer to have been using, I think it's logical to conclude that she had recently used those types of methamphetamine, would explain her behavior, explain why they were present there next to the bed. And I don't think necessarily she has, I guess, to be proved that she's living there long term. I think the fact that she was present in their close proximity to methamphetamine types, that she appeared to be high on methamphetamine, and her behavior was consistent with use methamphetamine. I think all, again, under a preponderance standard, which is more likely than not, that leads the court to a finding that she did violate her probation as alleged at counts 2, 3, by being in possession of methamphetamine at that time. There really wasn't a whole lot of testimony regarding the resisting arrest portion of this, and the court finds that there was not sufficient evidence to support, even under a preponderance standard, that there was resisting obstructing on the record before it here as part of this proceeding. So the court finds again that for probation as alleged at counts 2 and 3, not guilty of violating probation as alleged at count 1. Mr. Haven or Ms. Cove, either of you have a position as to sentencing in this case?
Your Honor, the probation agent for Ms. Schweizer is Mr. McFalda. He is not here today. He's been her agent for a long time. So I would just ask if we could set up a meeting in the next couple of weeks so he can have a chance to be present and make a recommendation.
Okay, so the court will set the matter for sentencing. Mr. Haven, if you can ask Mr. McFalda to prepare a violation report.
I will do that, Your Honor.
Prior to that hearing.
We still have the status conference to address.
Okay, how do you want to proceed on that?
So, Your Honor, at this time, I guess I would just ask the court to set this out to follow with the other dates, but I would like to address bond to the court.
Okay. Any objection to setting this for a status conference at the time of sentencing?
No, that makes sense.
Okay. So we'll set file number 245307 for a status conference at the time of sentencing. 2352228, and then Esteban, Mr.
Thank you, Your Honor. We have a somewhat unique situation here in that Ms. Schweizer was arrested on the probation violation, obviously on the date that she was found. She was brought before the court and she was arraigned on 2 different violations at the same time. She posted the bond in both of the probation violation matter, but frankly, after she was released from the jail, I think a day or 2 subsequent to that, she was rearrested on the new charges that form the new file. She has a new bond in that case that I believe is $50,000 cash or surety. I'd ask the court to consider reducing that, even if the court were to reduce it to a 10%. She doesn't have any ability to post that. We understand that there's likely to be jail associated with the violation, but frankly, she still does have some personal matters she needs to attend to before that jail sentence. In my mind, among the most concerning is her dog is still in the pound and she has no way to address that until she can get out. I'd ask the court to make her have a tether so we know where she's at, but if we could reduce her bond, we would greatly appreciate it.
And she knew the new charges were coming, and none of this came as a surprise to her, and how she handled herself in terms of bonding out and then getting rearrested. I think the bond is appropriate. We've had failures to appear. There's been issues with her reporting and probation. She obviously wasn't doing well on felony probation since we have a new methamphetamine charge. The court can be some but not all of the evidence in this case that we have. The likelihood of conviction is high. I think she is a danger to herself if she continues to use methamphetamine, and ask the court to keep the bond as it's set now.
All right, I agree with Ms. Coe for all the reasons that she just stated. I think that's appropriately said at this time. So the court will deny the motion to modify bond, and we'll go forward again with this file being set for hearing at the same time as the sentencing.
Thank you.
That also concludes